in the matter of the marriage of Brianna M. Kirkpatrick, now Hilton, and Caleb B. Kirkpatrick, respondent case number 2021 DM 135. Beginning with petitioner, would counsel announce appearances for the record, please?
Good morning, Your Honor. Steve Turley on behalf of the petitioner, Brianna Hilton. I appear by Zoom. Brianna is with me at my office. She also appears by Zoom.
Susie Locke on behalf of the respondent, Caleb Kirkpatrick, who appears in my office and via Zoom.
Matter comes before the court at this time upon a motion for attorney fee determination and final judgment filed by Mr. Turley on behalf of his client on January 27 of 2025. Ms. Locke, I received what looks like a Kansas Payment Center history report from you. Mr. Turley, do you have that?
I do.
Okay. Mr. Turley, what relief are you seeking today?
There are two issues before the court, Judge. One, well, before I proceed, do you have my exhibits that I mailed out?
I do.
Okay, great. There are two issues before the court. One is whether interest should be added to the judgment. And the second is whether my client and I should be awarded attorney's fees, and if so, in what amount. Within the materials that I sent you, Judge, one was Exhibit 5, which is a proposed order. That order is agreed to by counsel, but you'll notice, Judge, that there are some highlighted parts of the document. Those highlighted parts are where we have open questions and need some direction from the court. So we've got the journal entry pretty much worked out once we get a decision from you, Your Honor, on these remaining items.
I notice your creativity in the title, order.
What looks like a routine hearing quickly becomes a battle over money, accountability, and legal strategy. The attorneys walk in already prepared for conflict, and the judge wastes no time focusing on precision and professionalism. Even the title of the proposed order becomes a talking point, showing this judge pays attention to every detail. Right away, you can tell this isn't just paperwork anymore. This is about who controls the narrative and who walks away financially protected. Stay tuned because this hearing only gets more intense from here.
Mr. Turley.
What would you have called it, Judge?
Mr. Turley, this court is of a strong belief that each order and journal entry filed in a domestic case should define exactly what's covered by the terms of the order, at least some summary. I only make that comment is that it's difficult when looking through a listing of documents, especially an electronic file, when everything's called order, journal entry, order, journal entry, without definition as to what these orders and journal entries are all about. It just seems that the title should really explain a little bit better. That's not really what is before the court today, Mr. Turley. I do appreciate any drafting efforts that were made prior to today. I see paragraph 6 has question marks, and that's regarding your request for attorney fees.
Yes, the question marks are where we have open questions.
I'm looking at paragraph 7, which is your attempt to do a breakdown of disposition of proceeds.
Yes, Judge. The open questions are the attorney's fees and the additional interest, if any. The other amounts are agreed to.
Why is interest an issue, Ms. Locke?
Your Honor, the additional interest that has been occurred from this date of the sale until the date of this hearing, we don't think should be applicable because the funds have been held in Mr. Turley's account. We also suggested that the amount of the judgment should be released by an agreed order with the remaining balance held until these remaining issues could be resolved. But Ms. Hilton she wanted to wait and resolve everything.
One attorney argues the money sat untouched in trust and therefore interest should stop, while the other insists delay is not their fault and the law makes interest mandatory. What's fascinating here is how both lawyers subtly try to blame timing and procedure on the opposing side without directly attacking each other. This is classic courtroom positioning. Stay respectful while strategically shifting responsibility. The judge listens carefully, knowing even a few $100 can represent a much larger principle in divorce litigation.
At once. So our position is we shouldn't be paying interest on a judgment when the judgment could have been paid, but we didn't have the opportunity to pay it because the funds are held pursuant to the court order.
Mr. Turley?
Ms. Locke is mostly correct that the funds remained held. I agree with her that she had proposed at one time that we do a partial distribution. And I explained at the time that I didn't agree. This wasn't my client's decision, it was mine. Part of the reason being attorney's fees is an issue before the court, and that would have required me to do additional work, which would have just further exacerbated the problem that we perceived to have existed. So, and then I will also observe that this hearing is approximately 2 months later due to no fault of my client or mine. I'm not saying it's anybody's fault, but we weren't the ones who requested the continuance. So our position is interest accrues by law. It's mandatory. It's not discretionary. The statute's very clear on that. And so that one's simple, though. I think you've heard everybody's pitch on that issue.
All right. The court's prepared to rule on the interest issue. A combined judgment was entered of record on November 22nd of 2024. It will be the court's ruling regarding what interest can be enforced against the fund. We'll start at 11/22 of 2024 on a judgment amount of $29,438.70. Interest will terminate as of the date the money was actually deposited into Mr. Turley's trust account. What date was that, Mr. Turley?
I don't have that answer at my fingertips, but Ms. Locke and I can figure that out.
All right. At that point, Mr. Kirkpatrick.
The reasoning is simple but powerful. Once the funds were effectively under attorney control, the respondent had essentially paid what he owed. Then comes another important moment. The judge acknowledges the respondent's efforts to stay compliant with payments, even correcting missed installments. This matters because judges watch patterns, not isolated mistakes. Compliance after contempt can heavily influence future rulings, and you can already see the court balancing accountability with fairness in real time.
Patrick had essentially paid what he owed. He didn't physically turn it over perhaps, but at that point the funds that belonged to him were under the control of Mr. Turley's office, and the court deems that to be the appropriate date to terminate the computation of interest. I don't really know what we're talking there, several $100s perhaps.
Yes.
I also will note that Mr. Kirkpatrick has been, for the most part, complying with the court's order regarding how he was to purge himself from contempt. He made appropriate $1,200 payments in November, December, January, skipped February for some reason, but then made payments in both March and April. Now, $200 of that each month is to be credited toward arrears, is it not?
Yes, and that will be included in the calculation, Judge.
All right.
And Your Honor, as a brief update, when Mr. Kirkpatrick and I were discussing before the hearing today, we both noticed the February payment. He made that payment this morning, and I sent the confirmation to Mr. Turley. So he is fully caught up on any arrears.
Well, okay. He made the February payment in April. All right. So what he did is he doubled up in April.
Correct.
To make up for the payment he missed.
Yes.
All right. Well, I appreciate those efforts, truly. All right. So, Mr. Turley, is it a fair statement then the remaining issue is what, if any, attorney fees should be allowed to your client for having to pursue her prior motion?
That's correct.
All right.
The petitioner's lawyer lays out over $11,000 in requested fees and immediately frames the entire case around misconduct and poor decisions by the opposing party. Notice the strategy here. He's not just asking for reimbursement, he's arguing that the other side caused the litigation itself. That's a major difference. The attorney carefully connects parenting disputes, contempt findings, and alleged bad judgment into one larger narrative designed to justify shifting the financial burden. In family court, whoever controls the fairness argument often gains the upper hand, and that's exactly what's happening here.
And let's clarify for the record what amount you're currently seeking.
So Judge, this is outlined in our Exhibit 6, starting at page 26 of the materials. And that's our motion. And then the next exhibit after that is my affidavit regarding my client's costs and attorney's fees. Attached to that affidavit is a billing summary with all of the entries and charges. I went through it, initialed each page, and signed that document. And after totaling everything up, we're asking for $11,406.
Let me make sure I understand. You're wanting Caleb to pay for your attorney fees in pursuing relief on behalf of your client, not related to contempt?
That's correct.
And why is that fair?
So at the trial, Your Honor will recall, basically all of the facts were related to things that Mr. Kirkpatrick either had not done in violation of a court order, those things being the contemptuous behavior, and also those things he did or didn't do that negatively affected the minor child. So these parties had come up with a parenting plan, and the evidence at trial was that there were serious concerns about drinking that Your Honor even noted yourself. And so our position is Mr. Kirkpatrick caused all of this litigation through his poor decision-making and at times contemptuous behavior. So we think that as a matter of justice and equity, my client should be entitled to her attorney's fees on everything. And as I noted in the affidavit, she was charged a significantly reduced rate as compared to my current customary rate.
All right.
Instead of denying every allegation, she narrows the issue and focuses on compliance. Her argument is straightforward. The contempt was already addressed through the court's purge order, and her client followed it. Then she pivots to something even more important. The petitioner already has access to nearly $30,000 sitting in trust. That changes the optics completely. Suddenly the request for attorney fees starts looking less like necessity and more like punishment. This is a smart defense strategy because judges hate seeing fee awards used as revenge instead of reimbursement.
Ms. Locke, your client's response to this request for attorney fees.
Your Honor, we would ask the court deny the attorney's fees. Related to the parenting time, the court reduced my client's parenting time. Related to the other contempts, and the only spots where the court actually found my client guilty of contempt were the failure to pay the spousal maintenance and the child support. The court then entered a purge order, essentially, which said the contempt would be purged if you complied with paying $1,000 a month in support and paying an additional $200 a month. My client has done that. He's been compliant with the court's purge order. So that should purge his contempt. There should be no additional award of attorney's fees related to that. Additionally, there's some case law cited by Mr. Turley, and one of those is the financial needs and the ability to pay of my client. Well, as the court just noted, Miss Helton has had the opportunity to take at least almost $30,000 worth of cash that's sitting in her attorney's trust fund, a judgment that was awarded to her. But she elected not to. So we would question whether there truly is a financial need. These funds have been sitting there for 4 months now that she could have accessed and we would have entered an agreed order for. So our position is that at this point, the award of attorney's fees is not just inequitable, it is truly a punitive sanction, and it's not reasonable and it's not appropriate.
Any reply argument, Mr. Turley?
Yes, Judge, and there's just a couple things I'd like to touch on in addition to what I said earlier in response to Your Honor's question. So Ms. Locke correctly notes that in our motion, we've cited some law.
He separates the contempt issue from the custody dispute and insists the contempt portion should be an easy call because court orders were knowingly ignored. What makes this powerful is how he frames attorney fees as protection of the original judgment itself. In his view, if his client must spend money just to enforce orders already entered by the court, then the value of that judgment gets reduced. That's a persuasive equity argument. Then he expands into financial disparity, arguing one side has greater earning power and therefore should absorb more legal costs. This is less about technical law now and more about convincing the judge what fairness truly looks like.
For the proposition that the court can and often does award attorney's fees in a contempt situation. So as to the contempt piece of this, I don't even think that's a close call. Mr. Kirkpatrick was under a court order. He disobeyed it willfully, as Your Honor found. And importantly, in this case, this was not a situation where Brianna charged into court on some technical violation or something like that. She waited a very long time for Mr. Kirkpatrick to become compliant, or gave him the opportunity to become compliant. And as I recall, at trial, there were text messages and other things of that nature entered into evidence that showed her informal efforts to get what she was due from the agreed upon judgment. Mr. Kirkpatrick ignored those requests. She had to pay her lawyer. And so if she's not awarded attorney's fees on the contempt issue, it effectively deflates the agreed upon judgment that she contracted for and she had to enforce through the contempt motion in the first place. So as a matter of justice and equity, we think that part of it should be an easy call for the court. In all candor, Judge, as Your Honor already alluded to, the closer call in my estimation is whether Brianna should be awarded any attorney's fees on the custody and parenting time issues that were tried to the court. And there's two reasons that we think that the court should award attorney's fees there as well. One is the disparity in financial positions. I cited for the court the Dunn decision in our motion. And as Your Honor, I'm sure already knows, the Dunn decision stands for the proposition that when evaluating a request for attorney's fees, the court has to consider need and ability to pay as it would in a spousal maintenance dispute. And that's.
He emphasizes reduced billing rates, trial preparation, and the amount of work involved, trying to show the court these charges weren't inflated. But here's the interesting part. He also leaves room for compromise. After requesting the full amount, he signals willingness to accept $7,000 or $7,500 if the judge isn't prepared to grant everything. That's a subtle but important tactic. Experienced litigators often give courts a softer landing instead of forcing an all-or-nothing decision. It allows the judge to partially agree without feeling cornered.